for you to hear.
It's on the jail docket, unlawful camera. Okay, go ahead, Judge.
On January 8th, 2025, the officer observed the defendant's motor vehicle fail to signal for 100 feet prior to making a lane change twice from lane 3 to 2 and then from lane 2 to 1 on East Tex Freeway in Harris County, Texas. A traffic stop was initiated and the officer observed further movements between the occupants of the vehicle before the driver, defendant Price, age 19, rolled down the windows of the motor vehicle. The officer approached the motor vehicle and observed a clear plastic bag with green liquid in plain view in the driver handle, believed to be promethazine based on training experience, and a bag with marijuana in the driver door pocket. The weight of the marijuana was 0.82 grams, and the promethazine was 101 grams. The officer observed an AR pistol in plain view on the rear left floorboard or left rear passenger seat, where the defendant, Guidry Royale, was seated. Guidry Royale, age 19, and a PC search on the motor vehicle was conducted, and the officer observed another AR pistol inside a black backpack in the right rear passenger seat where defendant Kinnan was seated, along with defendant Kinnan's cell phone. The officer observed an unholstered Glock in plain view adjacent to the first AR pistol on the floorboard behind the driver's seat. The defendant, Guidry Royale, stated the firearms were passed from the front to the rear of the motor vehicle, but would not state who handed him the firearms.
If I may, Judge, hear the issue. So some stuff that's not there is that they were looking at this vehicle beforehand. This is
remember, this is a probable cause hearing. I mean, I can't get into like,
right.
You know,
it's a suppression team. They're looking, they're following. It's a pretextual stop. They're following them, waiting for a reason to stop them. The reason that they give is didn't signal for 100 feet. Sounds like they're on the highway. Okay. It's a conclusory statement. They're not stating that anybody else was in danger. They make no mention of.
Well, failing to signal a lane change is a good, I mean, that's a traffic violation, is it not?
Well, 100 feet. They don't say at what point he failed to signal, whether or not he signaled at all, whether or not he signaled under 100 feet. They don't state at what foot or feet he did signal. It's conclusory. They don't give articulable facts regarding that. And so because it's conclusory and we don't
I don't know. I think that there's enough probable cause to go.
Here's the second issue, Judge. The second issue is in the DIMS, this officer is stating that my client says they passed the gun to him and they handed the gun to him. That's what the DIMS says. But the OR says that my client says he doesn't know who tossed them from the front to the back. He doesn't say they handed it to him. He doesn't say they passed it to him.
But there was also an AR on the floorboard where he's sitting. Right?
He said that they're not his. There's 4 people in the car. There's 4 people in the car. And only 3 out of 4 get charged with an unlawful carry of a weapon. He doesn't say, hey, they handed it to me. Hey, they passed it to me. What he says specifically is doesn't know who tossed them from the front to the back. This correlates to the furtive movements that the officer is talking about. He never claims possession of these guns. The guns are all in the car. He says they're not his, says the guns are not his, but he gets charged for the UCW.
And we're supposed to just take it, then just believe his, right?
And Your Honor, if I may, and that's why, because they were found in the area where he was seated, the AR pistol, and he is underage at the time. That's the reason why he was charged, because he had them in his immediate proximity in the vehicle.
Yeah, I think that there's enough. Sorry?
It would be a question of fact, Judge.
Okay.
I think that there's enough. Sorry.
Okay. Understood, Judge. Thank you, Judge.
Thank you, Ricardo. Mr. Doyle, you ready? Sure. Mr. Kim.
Hello.
Happy
Judge.
Friday.
Happy Friday.
Happy Friday.
I'm here on Mr. Reader.
Reader. Yep.
He's finally here today.
Do you mind bringing him out? What's new? Everything all good?
Just, kicking off the new year. Kid stuff. How about you?
Same thing. My life is revolves around kids,
My son still won't wear long pants, he'll still wear shorts.
In this weather? Are you?
That's a thing.
My daughter wears them fine, but yeah, my son just refuses.
How old is he?
He's 8, so.
He's 8?
Just doesn't care. He'll freeze to death before he admits.
Hopefully he's wearing a jacket and a sweater. I mean,
Looks comical. Yeah.
I love shorts as well, and I hate wearing pants too, so.
That was after.
Are you opposed
So I'm not opposed to a bond, I'm just opposed to a low bond. And so council has shared some more information regarding, because we haven't been getting, it's another one of those, we can't get a hold of the people from the demanding jurisdiction. It's one of those because it's a 2B warrant, it hasn't been assigned to a prosecutor yet. And so we were trying to get a hold of the actual investigator for this charge. And Amy and I got shuffled around a little bit, so we could only speak with the extradition investigator, but we couldn't speak with the original investigator. So my facts are very, very limited. We don't.
I'm happy to give you some background, Judge. Mr. Reeder, military veteran, was a medic in the Pacific, in Korea, meritorious awards, done well. When he finished with the military, the Army, lived in Georgia, then was hired over here by a very reputable hospital and medical center. He's the lead administrator. He was referred to me by the chief neurologist of this hospital. What ends up happening, he is in a custody dispute, and I believe Judge Kirby's, is that the judge, over in family court?
Here or over there?
Here. As this custody dispute sort of soured for his future ex-wife, he shows up at his hospital to go to work and is sworn and arrested on a warrant that he had no idea about. Apparently, this is some allegation that occurred in Georgia in June of 23. No report was made at the time. I think the state will confirm that. It wasn't until the custody issue here started to go south for his future ex. She then makes an online report in DeKalb County, Georgia, who accept charges without ever even talking to him, getting his side of the story. There's actual video evidence, I'm told, of what happened that's been litigated in family court. They're not responding to the state. All we want is a low bond so he can go deal with this there. He's not a flight risk. He's not family here. He's obviously got a good job. His boss is the one who brought me in on this. And so, I don't want to ask for a dollar bond, but I ask as low as the court wants to go because it is a cash bond, and he's going to have to go hire a lawyer to deal with this.
So you're not going to go represent him over there?
I'm not going. I'm going to get it. I know. I stay in my lane.
Got it.
We're going to find somebody in DeKalb County that'll make this go away.
So, Mr. Reeder, you are wanted out of the state of Georgia for aggravated assault and cruelty to a child. What we have here is, I don't know you. I've never met you before, but my main concern are two. Are you a danger to my community? And number two, most importantly, are you going to go back to Georgia? I have to make the bond sufficiently high if I give you a bond so that you're going to go back, because you are, as everyone, it's an inherent flight risk because you're a fugitive from another state.
Judge, if I could, one other thing. The aggravated assault, my understanding in Georgia, is the impeding breath statute here, and the child part of it is the allegation is the 12-year-old child witnessed this. So it's not, there's no weapon involved or anything like that. It's a simple domestic violence situation.
Any prior criminal history?
No, he has no other history, Judge. And so I'm not able to confirm, but that seems logical in terms of when the warrant was dropped, but it is correct. The charges, the Texas equivalent would be impeding breath, and I guess, I don't even know if we have.
You don't know this with certainty that that's
the charges it is, but for the date, I don't have any other information. Like I said, I
don't know the actual, what the facts, what the.
Yes, the strength.
Eating breath, or whether it's shooting a gun.
And then cruelty to, it's strangulation, and the cruelty to child is the fact that the 12-year-old witnessed him allegedly strangling his wife. So, but regarding that, because of the nature of the charge, it's that state requests a $10,000 bond. And so. You're okay with the bond? With a bond being set because he has no prior other criminal history. He hasn't exhibited any other information I could find that he's a flight risk. So.
Okay. So state wants a $10,000 bond. What's your counter?
My counter would be 1,000, Judge. He's not going anywhere. He's got a good job here. He's got support here. I'm here. They're not bringing me here to run away from anything. We're going to go fight this case and clear his name. Everything's here.
You got to understand that, if I set you a bond, we expect you to follow through, and there are very serious consequences. You're old enough to know that actions have serious consequences, and if you fail to act, I'm going to set you a bond, and we give you 14 days from the date of your release to go turn yourself into Georgia. If you fail to do that, I'm telling you now, I'm not going to play this game with you again. If you fail to go, I will issue a nationwide warrant for your arrest, and I'm going to set your bond at 0. You won't get another one. Do you understand?
Yes, Your Honor.
I don't know. So he wants 10, you want 1,000. I'll set it at 5, you know?
Would you consider 2,500? Because my understanding it's a cash bond. So we have to pay, we can't get a bondsman in here, pay the 10%. And he's going to need money.
I defer to the court. Sorry, I was working on the waiver withdrawal form because he waived in magistrate court. So I'm just working on the waiver withdrawal right now. But I defer to the court. Because he doesn't have any other history and because I'm limited information, it's hard for me to make any further assertions because no one's getting back to me.
Credit, they've gone out of their way to reach out to Georgia, and they, and they're not responding. It's not
he's great.
Lack of diligence on their part. But apparently, DeKalb County doesn't find this as much of a priority to respond to them, and they've had 2 days while he's been sitting in jail.
Okay, I'll acquiesce to the 2,500.
Thank you.
Moment, I have one form. Give me like 5 minutes.
The only other thing that I'm going to counsel you is that you got to be careful, man. You know, what you do impacts everyone around you, you know, especially a child. You know, hell hath no fury like a woman scorned and a teenager out of control, because the teenagers that's out of control can make your life a living hell. And when they see that kind of, it impacts everyone. And I'm telling you, it reverberates and it can just, like an infection, just grow out of control. 90% of the people in there now, no self-control. They get upset, they wig out, and they just go without thinking, hey, if I do this, what's gonna happen? If I say this, what's gonna happen? Patience really goes a long way, you know? All right, I'll set the bond at 2,500. Just be careful, man. All right? Okay, Mr. Doyle.
Thank you, Your Honor. Now,
Thank you, Judge.
excuse.
Yes, sir. I have to, hold on a second. Hi.
Hi, good morning, Your Honor. I'm approaching on last name Moore, first name is Sheena.
Okay.
We have a ground violation.
Moore, come up. Please show up for the drug test. We're not asking for much. I'm going to send you for a test now. If you fail it again, it's not going to go well for you. Okay? All right. We'll send it for a test now. Assuming everything's okay, we'll just give you normal reset, but please, no more. All right? Okay. Good luck, man. Give me a second, guys. When you're cool, the sun shines on you indoors.
Well,
No?
it's because brilliance from the bench is blinding me. So,
How are you?
it may be that coat.
That's what it is.
I'm good, Judge.
Mr. Coyne.
Angel Gutierrez, it's a DWI. I understand that you might want to talk about bond conditions.
Is this a new case?
Yes, it is.
Judge, it's simple arraignment, it was in felony court.
All right. Mr. Gutierrez, come up.
Page 5.
I take it you are also representing him upstairs.
I am, Your Honor.
Wonderful.
Oh, sure.
Mr. Gutierrez, you were charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On January 4th, 2025, at approximately 12:58 a.m., the officer observed the defendant's vehicle with no expired registration as of July 2024. A traffic stop was initiated, and the officer made contact with the defendant and driver of the vehicle. The window was not completely rolled down, and the officer observed slurred speech, and further discovered the defendant had an open warrant and asked the defendant to step out of the vehicle. The officer observed an odor of alcoholic beverage and bloodshot eyes, and the officer did search of the defendant and found a marijuana blunt in the defendant's front pocket. The defendant stated he was coming from a bar and was driving home, and the defendant stated he had one cocktail drink and 2 shots. The defendant admitted to smoking the marijuana before going to the bar in the car, and the defendant stated he was 3 out of 10 drunk when asked to rate his intoxication. The defendant refused to send a field sobriety test, and the DIC was read to the defendant, who refused to provide a breath sample. A blood search warrant was signed and executed.
Gutierrez, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I'm going to put you in jail. No more PR bonds. Do you understand?
Sir.
He has a prior FSRA and he's on bond for that case. Has anything happened to that because of the
I
DWI?
just signed on to that case. He was just recently arrested for it. We're in the beginning stages of
Did it to be?
It was. We're in the beginning stages of discovery, Judge. I know almost nothing about that case yet.
Was there a dead body?
No, Your Honor. It was a minor injury.
Great.
Yes, Your Honor, this is a leg injury.
On the FSRA?
Yes, all right, yes.
Okay. All right. Does he have a Texas driver license?
It's eligible, Your Honor.
All right. You are not allowed to drive unless you also have liability insurance. If you don't have liability insurance with your Texas driver license, you're not allowed to drive. If I find that you're driving also without insurance, I'm going to revoke your bond. Do you understand? All right. Now, you got a great lawyer. It's your responsibility to listen to Mr. Coyne, and he'll tell you when you have to come back to court. If he tells me that you're playing games, you're not responding to phone calls or text messages, I will issue a warrant for your arrest. Don't pick up a third case. 3 strikes. You know what happens, right? All right. Come on. Thank you.
Judge.
He's going to have to get with Felicia for bond conditions. We'll have him sign a reset, and then you're good to go.
Thank you, Judge.
Right this way.
Yes, sir.
Had a wreck. I had surgery, so
Always a pleasure.
I wouldn't be disrespectful to the
I trust you. It doesn't matter. Mr. McAllister, I heard the wonderful news.
Yes, Judge, and I actually hear about that, just an administrative stuff. I was hoping you'd sign the motion to substitute to free up Peyton. Did you, on a certain cause number?
Are you now inheriting hundreds of cases or what?
This one, yes. And this one in particular is just one of those, they're on PTI and they have a setting next year, but we got to free him up because he's getting sworn in on Monday, so.
Tell him congratulations from me, will you? You know, that's great.
Yeah, but we're all scrambling just to
I can't even imagine, you know.
change the name of the website. There's some administrative stuff going on, but,
I got it. I'll sign it for you.
you sign it for?
Yeah, of course.
Yeah, okay.
Just let them know.
I'll let them know the
I
cost.
think I may have already signed it. Actually, it's a motion to sub.
Yes. You signed it.
You signed it? You already did it, Judge. Sorry, before I left the courthouse, I told him I.
You're okay?
Thank you, Judge.
Take care. John D.
Judge, this is Ms. Prince.
All right. Good morning, Ms. Prince.
Morning.
Ms. Prince, you were charged with false report to a police officer. You were facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 5 days in jail with credit for the 5 days that you've done. You need to understand that by pleading guilty, this charge is going to go on your record. It's going to be there for the rest of your life. From now on, you'll be facing a minimum of 90 days in jail. Do you understand?
Yes, sir.
You were giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this, you can never change this or undo this.
Yes, sir.
How do you plead to the offense, ma'am?
Guilty.
I will find you guilty, sentence you to 5 days in jail, give you credit for the 5 days. The enhancement will be abandoned, and good luck to you.
This is where the defense makes a classic suppression-style argument. They're basically saying, Judge, this stop might be legal on paper, but where's the detail? In probable cause hearings, vague claims like failed to signal can be attacked if they lack specific, articulable facts. But here's the twist. Even a minor traffic violation can justify a stop in most cases. So the real question is, do you think this was a legit stop or just police looking for an excuse to pull them over?
Girl Nabiyama.
He's in custody. He was put out on bond for a felony and he picked up this DWI. So he's set for bond. Has the bond already been set for this one?
Let me see. Oh my goodness, 100,000 on that Agra, or on the Agra salt, huh?
Yeah, he doesn't think he can make it, so.
So what happened? He was out on bond for this?
Yes, well, I'm not over the felony, another attorney at the firm is, but yes, from my understanding, he was out on bond for the felony and then he picked up this DWI.
So they revoked it and raised it?
Yeah, they revoked it and raised it, yeah.
Okay, whatever you want, you know.
Set it at 1,000.
Well, but the bond is set at 5,000.
Oh, it's already set?
Already made bond.
Okay.
So there's nothing really for us to do. Felony court is 116. You want to set it for the day after? Or do you want a longer reset?
A long reset, I don't think it's gonna get some.
Okay, whatever you need.
Thank you, Judge.
Yes, ma'am. Thank you.